Welcome to Easy Learning. The submissions of both learned senior counsel resolved essentially around the various judicial pronouncements relied upon by the Medical Council of India while issuing the impugned order. Mr. Sethi would submit that the MCI erred in rejecting the petitioner's application on the ground that the time periods stipulated in the regulations were sacrosanct and that rather the extant legal position was otherwise. Per contra, Mr. Singh, appearing for the MCI, would seek to contend that a reading of the various authorities on the issue made it clear beyond pale of doubt that the MCI could not have accepted the consent of affiliation issued by the Kerala University of Health Sciences after the last date for submission of the applications had expired. The controversy would therefore be required to be adjudicated upon on a holistic reading of the various authorities governing the issue. It would be appropriate to proceed in this regard chronologically. Before the division bench of the High Court, the MCI contended that though the central government had on 23rd December 2015 asked the MCI to review its recommendation, it was not possible to accede to the request in view of the time schedule fixed in that regard, which required the MCI to give the recommendation to the central government for issue of letter of intent by 15th December 2015. The division bench of the High Court held against the MCI, promoting the MCI to move the Supreme Court in appeal. The applicable regulations required the applicant to apply to the central government for permission along with the permission of the state government, university affiliation and other documentary evidence, including the essentiality certificate issued by the state government. The issue before the Supreme Court was only whether the application of the institution could be permitted to be processed in the absence of the essentiality certificate. The Supreme Court answered the issue in the negative. The appeal was, however, disposed of by granting permission to the institution to produce the essentiality certificate issued by the state government within 8 weeks, inasmuch as it does not squarely address the issue of the extent to which the time schedule stipulated for submission of the application and processing thereof at various stages was binding. This judgment does not really assist in adjudication of the dispute before this court. It is trite that before relying on a judgment, even if rendered by the Supreme Court, one is required to take into consideration the controversy which was engaging the attention of the Supreme Court while delivering the said judgment, as well as the fact scenario in which the judgment was delivered. Clearly, the time schedule prescribed in the 2000 regulations binds. The application submitted by the petitioner was unaccompanied by the requisite consent of affiliation by the KUHS, and that position remained unchanged till the last date for submission of the application. The matter ends there. It was not possible in the circumstances for the respondent to accept the application merely because the consent of affiliation was provided by the petitioner on a later date, or even because the inability of the petitioner to provide the consent of affiliation originally was owing to no fault of the petitioner. There is also merit in the submission of Mr. Vikas Singh, learned senior counsel, appearing for the MCI in this regard, that as per the stipulated time schedule, it is required to furnish its final recommendations by 31st January 2019. After conducting a lengthy and time-consuming exercise involving multiple inspections, which is even practically impossible. No exception can therefore be taken to the impugned decision of the respondent to reject the petitioner's application. Needless to say, this would not preclude the petitioner from filing a fresh application for the next year, which would be considered on its own merits and strictly in accordance with the time schedule stipulated in the 2000 regulations. Subject to the above caveat, the writ petition stands dismissed with no order as to cost. Full stop.